Well, I'm very excited to welcome you to the opening lecture in this series on my new book, Artificial Intelligence, Neurodata, and Society, Law at the Edge of Cognition. Um, I've been working on this for a couple of years now. It took a little bit longer than I anticipated. And this lecture series is to kind of give you an overview of the subjects that we talk about in the book, chapter by chapter, prologue by prologue, afterword by afterword. And what I'm trying to do in this book is explain to you a different type of AI that is going to come and questions whether or not we as a society are prepared to deal with the insights and the way that that AI will operate and change our lives. So the prologue does something intellectually important before any detailed analysis in the book begins. It refuses to let us reduce the subject to a catalog of devices or data sets or newly proposed rights. The book asks us to notice a change in the relationship between computational systems and human agency. Artificial intelligence no longer merely records what we do or what we did. It doesn't just predict what we may do next or present us with information. Increasingly, systems are learning how to deliberate, hesitation, emotion, an intention, how these all unfold and what they look like, and then how to act on that learning before the options to make a choice becomes visible. So that's the opening problem of what I call and what I term NeuroAI. It's also the organizing idea for the entire series. The legal challenge lies not only in access to the mind, but in systems that become capable of shaping the conditions under which the mind reaches the decision. That framing places institutional power rather than novelty at the center. The three not only statements on this slide are deliberate. Neurodata matters because it supplies intimate signals. Neurotechnology matters because it captures, decodes, or modulates those signals. Neurorights matter because they attempt to articulate limits around mental privacy, cognitive liberty, and integrity. But none of those categories, taken alone, identifies the full object of inquiry. My book uses NeuroAI, the term, as a wider governance lens. It describes systems that learn from neural data, from behavioral and biometric proxies calibrated against neural ground truth, and from the patterns through which people pursue goals. Those systems do not simply know more about the subject. What they do is they convert knowledge into anticipatory power. They reorder information, allocate opportunities, change timings, vary friction, and adapt environments around a probabilistic account of what a person is likely to think or do. The move, therefore, is from protecting a data category to governing an architecture that can act upon cognition across different contexts. It also prevents device-bound analysis when cognitive governance survives the original signal. This slide explains why the argument follows naturally from the law of deceptive design, my previous book. Dark patterns taught us to look closely at interfaces, things like defaults, obstruction, urgency timers, confirm shaming, and the many small design choices that exploit predictable biases. Yet static design is only the beginning. Generative systems respond to users. We're all familiar with large language models, but have you heard of large action models? These models go further than large language models because they learn sequences of conduct and can plan how to move from a high-level objective to execution. A model tasked with maximizing retention or completing a transaction does not need a designer to pre-program every intervention. It can detect user friction, choose the right response to that friction, observe the result, and then recalibrate. The important legal shift occurs here. Manipulation no longer resides in a visible button or a single misleading screen. It emerges from the ongoing relationship between model, objective, and user. The architecture keeps changing. My prologue, therefore, moves the inquiry beneath the interface towards systems that operationalize prediction as action. The escalation lies in autonomous optimization that discovers and personalizes its own route. The two data sets on this slide look unremarkable in isolation. Keystroke dynamics record speed, rhythm, pauses, and correction patterns. Anonymized medical records support legitimate clinical research. Place them within the same learning architecture, however, and a model may identify patterns that correlate with early, for example, cognitive decline. That's an extraordinary promise. Earlier detection could support treatment, planning, autonomy. But the chapter's sharper point concerns portability. Once the model learns the relationship, the inference does not remain morally attached to the context that justified its discovery. An insurer, for example, can treat the same pattern as risk. An employer can treat it as declining capacity. A platform can treat it as a vulnerability. No direct blame signal needs to travel. The learned correlation travels. This is why benign purpose and valid consent at the point of collection cannot resolve the whole problem. The legally significant object is the efferential capacity that persists, migrates, and becomes available for secondary cognitive use. The question is, who controls the correlation after the discovery? Because of the complexity in some of the things that I'm discussing in the book, as a narrative tool, I offer a few scenarios or vignettes to help contextualize some of that complexity. In this example, Mara's gives this abstract argument institutional form. She never wore a headset. The model learned from ordinary workplace traces, keystrokes, revisions, response timing, and task switching. It didn't diagnose her, formally classify her as impaired, or issue an adverse decision. Instead, the workplace changed quietly. Urgent tasks were sent elsewhere. Leadership opportunities disappeared. High-stakes responsibilities were buffered away from her. The system described this as optimization of the business. And that description really is important because it conceals the normative choice within a technical adjustment. Mara remains formally employed and formally free. Yet the field of meaningful possibility narrows around a prediction she cannot see. There is no clear proposition to dispute, no decision letter to appeal, and no human reason giver who can explain what happened. The scenario exposes a profound gap between individual rights organized around identifiable decisions and a system that governs through environmental preemption. The world has learned which choices to make unlikely. Mara's predicament is powerful precisely because everything remains administratively smooth. Injustice arrives through omission, rerouting, and disappearance rather than a dramatic refusal. The contrast on this slide identifies the jurisprudential problem. Law knows how to regulate words, acts, documents, bodily traces, decisions. Those objects enter legal processes in recognizable form. We can ask who acted, what was communicated, when the decision occurred, and which remedy follows. NeuroAI often operates before any such event. It infers continuously, adjusts incrementally, and shapes the background against which action becomes possible. Responsibility, consent, autonomy remain present in formal doctrine, but the practical conditions that give those concepts substance begin to thin. A consent box cannot tell us whether the surrounding environment has already been optimized to secure agreement. A right to contest a decision cannot reach opportunities that were never displayed. A prohibition on coercion may miss personalized friction that makes resistance progressively harder. The law may therefore remain intact on paper, while the architecture of agency changes underneath it. That mismatch drives the chapters that follow. A rights framework that waits for a visible decision may therefore arrive after the system has already distributed opportunity and structured the subject's future. The book develops this argument in a disciplined sequence. Part 1 maps the terrain. It defines neurodata, neuroprivacy, explains real-time decoding, traces pattern modeling and neurocapitalism, and shows how cognitive signals become training resources. Part 2 then places legal institutions under pressure. Policing begins to use neurodata as investigative intelligence. Courts confront machine interpretive cognition as evidence. Corporate platforms turn neuro-informed proxies into adaptive environments designed for engagement, loyalty, revenue. Part 3 asks how rights and regulations should respond. It tests the neuro rights movement, rehabilitates freedom of thought, and examines the EU AI Act as a concrete regulatory architecture. Chapter 8 then draws these strands together around the future of free thought. The movement is purposeful. First, understand the infrastructure, then observe what it does to institutions, and only then decide what regulation would have to see. That sequence lets the later chapters build a cumulative case rather than treating policing, commerce, evidence, and human rights as separate technology policy problems. The prologue leaves us with a demanding but precise claim. NeuroAI is not simply a privacy problem, a medical device problem, or a speculative debate about mind reading. It is a governance problem concerning systems that learn how cognition unfolds and increasingly intervene before choice becomes visible. The danger does not depend upon perfect prediction. A moderately accurate model can become powerful when institutions reorganize environments around its expectations. Nor does the danger require malicious intent. Optimization, convenience, safety, support can all become pathways through which inferred cognition acquires practical authority. The task for law is therefore to protect more than informational secrecy. It must preserve the conditions in which people can hesitate, deliberate, revise, and encounter genuine alternatives before systems quietly decide what should happen next. Do not forget to check out the next video in this series where we turn to Chapter 1, the machine that predicts your next thought, and begin mapping the NeuroAI terrain in detail. The prologue's challenge is consequently one of legal perception. We must identify anticipatory governance before its quiet adjustments harden into ordinary institutional practice.